Hello everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly community conference call every other Thursday. As usual, I will get started first with answering the questions that have been posted. Then we will look into any follow-up questions on the questions that have been posted. And finally, we should have a few minutes for any new questions. First question that has been posted by Dane. I have applied for I-485 for my wife. She's on H1 status. She's traveling to India and going for stamping. I believe that would be H1 visa stamping. If her visa gets denied or delayed, what will be the impact? Well, first of all, if you are the main applicant for the green card, her delay is not going to hurt you. Okay. But you can certainly bring her back on an H4. But the problem is her 485 may be deemed abandoned. So when she comes back on H4, you might have to reapply for her 485 if the priority date is still current. Okay. So worst case scenario may be a reapplication for 485. I don't advise people to travel in this situation because there is a couple of unclear questions. For instance, if she does not already have a visa stamp and she travels, has she abandoned her 485? I think USCIS can make that argument. If you already have a visa stamp on your passport, H1 or H4, and you travel without advance parole, I think you should be okay. But when you don't currently have a visa stamp, government can take the position that you have abandoned your 485 and she would have to refile it when she comes back. The last question you had was while making the visa stamping appointment, you answered no to filing of a green card. Um, well, if you cannot update the DS-160, actually the DS-160 has to be truthful on the date it is filed. Later on, things change. It should not make a big difference. Frankly, because H1, H4 are both dual intent visas, the fact that you have not reported her green card having been filed is not a big deal. But if you are still uncomfortable, you can always send an email to the consulate asking them the same question that the situation has changed. Do you want us to update anything? Okay. So that way you keep a record of your efforts to keep matters as close to the truthful facts as possible. Okay. Next question is Desi Virgo. I have a question around changing employers. I have an H-1B approved petition for fiscal 2015. So I have a soft copy of I-797 from employer A, but I have not gone for visa stamping. Employer B is ready to hire me. I'm a little unclear. Are you in USA or are you outside USA? Let's just see. Employer B is ready to hire me and offer me better role and responsibility. I assume that I'll be cap exempt, and the answer is if you're outside USA and you've got your visa stamping, only then you are cap exempt. This is what the government thinks. I think their interpretation is incorrect, but that's what they think. If you are in USA and if the old employer revokes your H1, USCIS will consider you to be cap exempt only if transfer has been received by USCIS H1 transfer before the revocation request. That's what they told us a couple of weeks ago. I can wait even till the end of the year for stamping. Yeah, you should go for stamping. It looks like you're outside USA. I think you need to get your visa stamped to be considered to be visa exempt, quota exempt. You don't have to travel to USA, but the last time we spoke with USCIS, they said they want you to get the stamping done. Otherwise, they don't consider you to be quota exempt. And this is, of course, I'm assuming you're outside USA. Vikas Chopra says, I became a permanent resident via marriage to a US citizen. So now then they are applying for naturalization. He qualifies under both categories. He's been married to a US citizen for 3 years, and he's also had a permanent residence for 5 years. You can apply under either category. And if you, I agree with you that um, the category under 3 years that requires more documentation, I don't see any reason why you cannot file as a lawful permanent resident for 5 years. Go ahead. I don't see any problems. Next question is RAA, RAA. So this is regarding an H-1B visa. My first US visa was business visa B1, B2, approved June 2010. Company X sent me on business visa the same month, stayed for 5 months and 27 days on that business visa from Company X, came back to India on December 2010. During this time period, Company X also got my H-1 visa approved, stamped from the US Embassy, came back to USA in Jan 2011 on H-1B visa from X. Company takeover, changed company to Y. New 797 got approved with new receipt number while I was in USA, and I started working for the new employer in December 2011. Came back to India Jan 2012 for vacations, got new H-1B stamped. During my visa interview, visa officer did not approve my new visa. Okay, they cancelled the previous H-1B and B1, B2, cancelled without prejudice. Okay. My question is, can any employer sponsor H-1B with an exemption of cap? That's a difficult one. I think you should be exempt from cap. Okay. The reason I say it's a difficult one is because USCIS's take on visa stamping is a little different, but my feeling is you are still cap exempt. Okay. Previous rejections should not have any impact on it because the rejections were not because anything you did wrong, it's because they did not think your employer qualified. Yogesh Angarkar, regarding renewal of expired EAD, AP, and returning to US on a different visa category. So I-140 is approved, I-485 is pending, EB3 category, return to India, AP has expired, EAD has also expired since 2012. Now I came back to USA on L1A category. Even though my EAD and AP have expired, can I reapply for EAD? Well, first of all, your 485 is gone, Yogeshji. When you have been outside USA and your advanced parole expired, your 485 was abandoned. You can refile the 485 if you are going to work for that same employer and they are willing to hire you back. Otherwise, all you have remaining there is the priority date. And because you're on L1A, getting a green card should be relatively easy. You can just go through EB1C category as international manager, which is a very quick green card. Within a year, you should be done. H. Gupta, I-140 approved with my current employer, got 3-year H1 extension. Now I want to change my employers. I don't have a copy of the I-140 approval, only the receipt number. Actually, we have had the situation before, and we've been able to get both the H1 extension as well as priority date transfer without an I-140 approval notice. So I think it should be possible. Can I use my old company's priority date with the new employer? Yes, you can. Should I join the new employer after getting USCIS receipt or final approval of H1? If you are already working with the old employer, I would suggest don't change until the actual approval is in hand. Once I join new employer, will my old H1B become invalid? It will not. But what happens is, as a practical matter, the old employer should revoke your H1 once you leave them. But it does not become automatically invalid. You can actually reuse that H1 if you had to come back to the old employer. I think there's some complication here, but to answer your question, does it become automatically invalid? The answer is no. Deepak says, I'm in US under H1B visa, child is a citizen by birth, wife used to be on H4 but switched to F1 and she's now working on OPT. Labor cert is done, I-140 not yet filed. I have an important family event in November, want to take my wife along. F1 denial, yes, F1 denial is possible because F1 can be denied for very many reasons. I would not want you to take a risk. Okay, I don't think it's a good idea. Even if you don't file an I-140, because once you file I-140, then you have basically named her in the I-140 application. And my understanding from reading the instructions and the regulations is that once somebody has been named in I-140, they have exhibited immigrant intent. So it becomes quite risky to go for F1 visa stamping. H4 work authorization may happen in August, September timeframe. It's difficult to say, Deepakji. I certainly hope so. If government really wants to move full speed ahead, they could get this done by September, October, August, September, October timeframe. August is, I think, a little too hopeful, but September, October may not be completely out of the question. So no, I don't think it's a good idea for you to depend upon the government issuing H4 EAD regulations. There is no way you can be assured when they will be issued or if they will be issued at all. So I think all things considered, you'll be better off going by yourself, not taking your wife with you. Arif wants to know, daughter is coming to the US for an MBA for 2 months. It's an exchange program. She got her F1 visa valid for 5 years till 2019. Does she qualify for OPT? No, 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 no. For OPT, you have to be in F1 status for 2 full semesters at least. And after that, when you finish your program, then you become eligible for OPT. Um, just because you're here for 2 months does not give you OPT. She will leave USA. So OPT is not even an option. Um, I think that pretty much takes care of all the questions because everything you asked was based upon a question or at least an expectation that OPT will be available. Are we there yet? 2015 says, I'm on an H1B, approved I-140 EB3, PD of March 2009. I work at a major public university, 12 years of research experience, 5 publications in medium level journals. I'm not doing any research, but in management. I am involved in research compliance. I'm being offered a senior executive role. Any possibility of an EB1? It doesn't look like it because extraordinary ability alien is definitely out. That's not available unless you can demonstrate that you're perhaps the top few percent people in the country who are at the very top of your profession. That looks unlikely. Outstanding researcher, your job is not a research position, and even otherwise, the resume seems to be not in accord with what USCIS wants. But I'm making a judgment based upon what you have told me. I think it's a long shot. EB1 is probably not a good idea. Fair PK, I got my first H1B with company A in 2006, came to USA in Jan 2007, worked here till 2009. Came back to India after 6 months. Company B decided to apply new H1B, and in 2010 they got you an H1B under that year's cap quota. Okay, so you got another H1B and you had been outside USA for more than 1 year. In July 2007, they applied in April 2010. Huh. You know, your situation looks like your company actually did use your existing H1 because otherwise you left USA in July 2009 and you applied the second H1 in April 2010, less than 1 year after you left. So that means there is no way they could have. Well, even if they use the quota, it doesn't really matter because you had already used up a couple of years of your H1, 2.5 years approximately of your H1. So you should have about 3.5 years of H1 left, it looks to me. Yeah, 3.5 years is what it looks to me because 2009 to 2015 minus approximately 1 year outside. So yeah, you are not going to get it all the way to 2017. Um, you came to USA in 2006, 2007, 2009. Yeah, so 2 years are gone there. And that 2 years, about, I would say maybe 3.5, 4 years are left. I'm doing a quick calculation here. So the time spent on your old H1B appears to be, it'll have to be included in your total 6 year period. Okay. Uh, AD wants to know, currently I'm on I-485 AOS pending since 2007. I have EAD and advanced parole. AP is expiring in August. Renewal was filed in May while I was inside USA. I left, renewal is pending. Is it okay to be mailed? No, you should travel back before your current AP expires on August 2nd, 2014. Um, I believe that to be the fact. We have had this discussion with CBP for similar cases, and at least up until 4 or 5 months ago, their answer was in a situation like this, they want you to come back on the old AP and then travel again using the new Advanced Pro. Sudipti is on OPT STEM extension ending Feb 2015. H1B has been selected, but now you have a better offer. You don't have to stick with the new employer. The only thing, and you can confirm this with USCIS, call their customer service. I was told that in a situation like yours, you can transfer out before October 1st, but USCIS must receive your H1 transfer application before the old employer sends in the revocation. Okay. So double check with USCIS customer service. They'll usually, in more complicated questions, they will put you through to a second tier support people who are the actual adjudications officers in the USCIS. GC India 123 says I have replied to my NOIR on an approved I-140. So the government wanted to revoke it. If the I-140 is not approved, then my 485 will also be denied. So what are my options? Well, some lawyers take the position that until the EAD is revoked, excuse me, until the EAD is revoked, you can continue to use it even after 485 is denied. So depending upon how aggressive you want to be, um, you could go with that position that even if my 485 is revoked, um, I can continue working until the government specifically revokes my EAD. I like to be more conservative, and I tend to just not work once 485 is denied. But I can understand if you want to be more aggressive about that. Okay. You really cannot stay up to 180 days after denial, but technically you are out of status and unlawfully present the moment the 485 is denied. That's why we tell people to keep their H1 active. Okay. Nevertheless, once the 485 is denied, you are unlawful and out of status. You can be deported. But nothing permanently bad happens until 180 days have passed. On the 180th day, you become subject to 3-year bar. Okay. Next question is Smita Pasquale. She's going to apply for father for green card. They need a marriage certificate. Um, they don't have it. Well, I think you should get yourself a lawyer, Smita. These things can get complicated. Normally, for family based cases, I don't recommend lawyers, but where you have these documents missing, government can lead you a merry dance. If you don't want to hire an attorney, what you can do is you can offer to do DNA testing and provide affidavits that show there is no marriage certificate and there are people who attended their marriage or who know they were married, provide copies of their passports, other evidence that shows that they are married and they have lived together as husband and wife. Along with that, offer to do DNA testing. Aya wants to know, visa applied for H1B, now on F1 OPT, cap gap. Job title is consultant at IT services company, working as a business analyst at the client location. Got trained in several systems that the client uses and gained IT knowledge. So, degree is MBA in accounting, undergraduate is in accounting, analysis, and auditing. Previous work experience is business analyst, working on software for financial analysis and accounting for 1.5 years. So, all told, you've got about 2.5 years experience, and then you've got an MBA. So now the question is, USCIS has asked for further evidence to demonstrate that I'm qualified for a specialty occupation and that I have a bachelor's degree in a field closely related to information technology. Okay. Am I eligible for H1B? You know, USCIS has been very almost dictatorial in denying cases like yours. So while I cannot comment just off the top of my head whether you qualify or not, I would have to look at the entire documentation. Take this very, very seriously because I have seen denials, especially when the title of analyst is used. So, business analyst, systems analyst. If you look at the RFE, I guarantee you almost that there is something in the RFE that says, oh, we have looked at the occupational outlook handbook, and it says that for analyst positions, a degree in a specific field is not needed. And this is a common issue that I've done a lot of consulting on. I have seen people have the same problem. So, how would I suggest you approach this RFE? Get yourself a lawyer. I don't know if you have one, but take it very seriously. You can lose your case because this is a difficult situation. Okay. So, other than that, I can't really give you much information because every case is different. What is your job description? How much of it is IT? How much of it is connected to your financial background or accounting background? What if you're developing accounting software? So I really don't know what to say. Okay, but take it seriously. DVN LGS says, my husband has an approved I-140 with current employer who's got his H1 as well. Company situation is dicey, it could close up. Can we port this green card and H1 to a new employer? Well, there's one problem here. I would say get yourself a new job as quickly as possible. Get your three-year H1 extension as quickly as possible and start a new green card as quickly as possible. There is a regulation that says if the company that sponsored your I-140 closes, USCIS will revoke your I-140. I don't think that takes away the priority date, but it definitely takes away the right for further H1 extensions after the one you've gotten. So the smart thing would be to get yourself an H1 approval with another company. Based upon the current I-140 approval, your husband can get a 3-year H1 approximately with any company. Okay, so get that done as quickly as possible. And you don't have to join them until the H1 is actually approved. That would be a smart thing to do. Dame got I-140 approval, EB3 to EB2 porting with new employer, priority date is current. Should I call USCIS and ensure my 45 is being processed? You can try in EB2 category, not in EB3. Yeah, you should, because their screen can tell them. If I quit my employer before getting a green card, will I be able to use AC-21? You can, if the new employer's job and current job are substantially similar for the EB2. Next question is Houston Krishna. He did a DOL complaint based upon my suggestion, and the employer has said that they are willing to pay 50% of his due immediately if I'm willing to close the case. Money is not important to me, but I wonder, is this going to cause my spouse visa status any issues? No, no. I personally think they should pay you 100%. Officer says they can't force them to pay full. I think they can pay them, they can make them pay the full amount, unless the company is close to bankruptcy or something. I wouldn't, I mean, I don't think it's a case that you should, normally, first of all, you should talk to a local lawyer. Our firm would not assist you with collections and stuff. Talk to another lawyer, see if they want to take this case on a contingency fee basis. I am surprised. I have never heard of Department of Labor settling for 50% of the amount that is due. That doesn't make sense. Maybe there's something here we don't know about. So involve a lawyer, at least have the case assessed. Okay. Does this require my wife to appear in court? Yes. How long will it take? A few months to maybe a couple of years to get a decision. Depends upon the court. Some courts are even slower. So I really don't know how long it will take. At least get it assessed by a lawyer who understands immigration as well as local litigation. Our last question that was posted today is, I have an approved from Eldhose EK. I have an approved I-140 with my current employer, planning to go to a different company. New company will start green card process after 1 year. Is there any chance I will lose the priority date of my current I-140? No. The only time you lose your priority date is if the old H1, the old I-140 is revoked by USCIS for fraud. Okay. Even if the old employer withdraws the I-140 or the H1B, you will not lose your priority date. Very good. We finished the questions that were posted. What I want you guys to do is, no new questions right now. We'll do new questions afterwards. But any follow-up questions on the questions that have been posted and answered, please press *5. Press *5 on your phone for any follow-up questions. No new questions right now, please. One question, *5. Okay, so it looks like we have only one follow-up question. Very good. New Jersey, go ahead, please.
Hello, Rajesh. This is regarding the complete closure question. So, the company filed Chapter 11 bankruptcy on Monday. We knew that only yesterday. So, in that situation with the approved 140 and H1 with the same company, I know you suggested us to file for the new H1 as soon as possible. With the bankruptcy filed, how do we go about it? Is it still safe enough to file for the new H1 and put this green card process, or what do we do?
Is your husband getting paid his full salary during the bankruptcy or no?
They just filed 3 days back, so we don't know much information as yet.
Okay, I would say you have no choice but to quickly, very, very quickly, file for a new H1 transfer. Okay, because if you don't, it will become very problematic. So very quickly file for an H1 transfer based upon the approved I-140.
So any new employer can file for an H1 based on the 140 approved?
That is correct.
Okay. Okay, so that will be our first step, and then can we use the same priority to start the TC process with the new employer?
You should be able to carry the priority date forward. But you will have
Okay.
you'll
So
have to
first they
you
just
have
the BH1 and then start the GC.
right, right, exactly. Okay.
Okay. Thank you very much.
You're welcome. Good luck.
Thank you.
Okay, we've got one more question, so let's go to Illinois. Go ahead, please. Illinois. Illinois, go ahead. Area code 224. Okay. Any questions at all, new or old, doesn't matter. Press *5 on your phone. Any questions, new or old? Press *5. Huh. Just 2 questions. Wow. Once again, Illinois, I have unmuted you. You can say hello. Illinois.
Hello.
Yes, go ahead, please.
Hello, Kanaka. I was not able to be online with your answers. My daughter is on the coming to US on the university MBA
Stop. I know who you are. I would really appreciate it if you guys log in on time and not make me repeat my answers.
Yes.
That's just not right. Okay. I will do it this one time, but I will refuse to do this in future. You guys will have to log in on time. If you can't log in on time, wait until the recording is posted. Now, that said, because your daughter is coming only for 2 months, she is not entitled to OPT. She does not get OPT. Okay.
I see. But she's got a 5-year valid.
Yeah, but she's not she's not going to study in USA full time for 2 years or 1 year. OPT.
You finish only 2 months, two
Yeah.
months, and go back, complete the MBA, and then she come back and then qualify.
No, OPT requires at least 2 full semesters of study in USA before you finish your education. This is something you should take up with the DSO, the designated school official, in the school that she's going to study at.
Yeah.
I don't see how she can qualify for OPT at all. Okay.
I see.
Yeah.
Thank you very much. Sir.
You're welcome, sir. Good luck. Okay, we have 2 more questions, and I remind again, any questions, new or old, doesn't matter. Let me go to, again, Illinois, Chicago, I guess. Area code 773.
Oh.
Go ahead, please.
Hello, Rajiv. My name is Hassan. How are you?
I'm good, Hassan. How are you?
Good. Just two questions, Rajiv. Like I have approved 140, and I have an EAD and advanced payroll, and I'm working with that company. And on the simultaneously, I have a Canadian PR also.
All right.
So right now, I'm working remotely with that company, and presently in Canada. And I just wanted to know, can I able to file my advanced payroll being out of country?
No, you have to be in the United States when you file for your advanced parole.
Okay, because my advanced payroll is getting expired soon, so I have to get inside the country and then file.
That is correct. You cannot apply for advanced parole from outside USA.
Okay, so that is mandatory because I'm not sure because whether they will check it out of country or not. I'm not sure how that law goes actually.
No, you don't want to take a chance with that. That could lead to your 485 denial.
Oh, okay.
All right.
So I have to come into the country and then file advanced parole.
That is correct. Do you have an H1 visa?
No, I don't have the H1.
Okay, yeah, you have to come into country.
And is there any issue that if I am working out of the country and maintaining my status over there, is it any issue on that? Or?
That's a very long discussion, Hassan. That's not something I can give you a snap judgment on. I will give you a very brief 2-line summation of 2 things that are important to understand. but I cannot take it beyond that because that's something you should be discussing with your lawyers, depending upon your
Okay.
immediate situation. See, one principle is green card is a future job. You don't have to be right now in USA to and be doing that job. So it's okay for you to be
Okay.
doing the job from somewhere else or doing something else altogether, as long as it makes sense in your circumstances. Second thing you have to
Okay.
remember is USA doesn't care which country you have a permanent residence to, as long as ultimately you are going to come and live in the United States. So the fact that you have a Canadian permanent residence should not be of concern to the United States. Okay?
Okay.
Good luck to you.
Yeah. Yeah. Because reason I'm out of country, I have to maintain the Canadian PR also.
You
So
need
that's
to
the reason
talk with
I'm
your
asking here.
lawyers about the exact situation you're in. They should be able to guide you better than I can in a 2-minute conversation. Okay?
Okay.
Good luck.
All right, Rajat.
You're welcome.
Thank you so much.
Bye bye. Okay, looks like the last question for the day. New York, New York, go ahead, please.
Yeah, hi, Rajesh. Thank you for the opportunity given. I think this is an excellent forum.
Of course.
I am a visitor to the US at the moment and completely ignorant of immigration laws. The first question I have before I ask you the question is this conversation going to be made public? And
Oh yes,
so,
yes, absolutely. This conversation is public. It is recorded. It is made available for everyone. In fact, when you log in, the recording tells you you are logging into a conference call which is being recorded. It will be made publicly available. So conceal your identity, conceal the facts of your case, and be aware that you are being recorded.
okay, lovely. Thank you for that. Um, my brother-in-law is a US citizen,
Mm-hmm.
and that's my wife's brother.
Mm-hmm.
I am 60 years old.
Okay.
If he applies for my wife for the green card for immigration,
Mm-hmm.
we are from India. How long do you think the process would take?
Approximately 13 years, and during that time, you cannot stay in the United States.
Or during the time you cannot stay in the US?
Nope.
Okay. And does that same principle apply to the children as well?
The same principle applies to your children. Yes.
Okay. I was told that this part was taken out, that nowadays if you're still in the pipeline for immigration, you could come and go.
No, that is incorrect.
No.
Let me clarify a couple of things for you. First of all, um, just because somebody's green card has been filed gives them no right to stay in the United States. Okay.
That is good.
Second, if your green card is filed, you could have problems entering on a tourist visa while the green card is pending because the government could refuse you entry at any time saying that you are an intended immigrant. So those are the two things you need to keep in mind. It's going to take about 13 years, and during that 13 years, can you come even for visits? We don't think so. It's up in the air.
But does that happen in practice? That most people who are in the pipeline are debarred from coming in, or is that more legally the position?
It is actually something that is completely at the discretion of the CBP officer at the airport. If they decide, well, you may not come back, go back to your home country, they could deny you entry. So it is definitely a practical risk, not just a theoretical possibility.
No, I understand, but practically does that keep happening? Is 30% of
I
cases
I do know of cases where people were turned back. Not only people, but old parents. Even though, I mean, their green card takes only about a year, but they were turned back at the airport after having traveled 14, 15 hours, which is ridiculous. But it has happened not very frequently. Brothers and sisters, I am quite sure if they find out, they would be inclined to turn you back. My guess.
Oh, Okay.
All right.
Thank you for your answer.
You're welcome,
Much
sir.
appreciated.
Good luck, sir.
Thank you.
Okay. We have one more question coming out of Richmond, Virginia. Richmond, go ahead, please. Richmond, go ahead, please. I've unmuted you, Richmond, area code 804. Go ahead, please. Okay,
Oh, sorry, I was on mute. Thanks for giving me this opportunity,
my pleasure.
Rajiv.
My
Can you hear me now?
I can hear you.
Yeah. So I have posted my question on the forum. The question is like I was on H1B. I got my first H1B with some company A.
Can I ask you to tell me the question
Okay.
number, sir? Can I ask you to tell me the question number?
It's 11.
Okay, thank you. Let me just pull that question out, make sure I know what's going on. Oh yeah. So my guess was you have about between something like 4.5 years left on your H1.
Um, I mean, do you really think that I have 4.5 hours left on the H1?
I think so because you see, you came to USA in Jan 2007 and worked till July 2009. So that's about 2.5
Right.
years. 2.5 years, right?
Exactly.
Then you left USA and you are continuing the same thing, but you were not gone for over a year. You applied for H1B again in April 2010. And did you say that you applied? That would have been obviously under the new quota using remainder option. There is a gray area here that makes me reluctant to commit because there are some interpretations possible. But I would say at least 4 years minus 2.5 years is definitely there. I don't see any issue with that.
Okay. I mean, that actually makes my day. I mean, I was kind of worried that
No, no.
by end of this 2015, I completed my, I mean, my whole 6 years of
No,
career
I think I
not
I
eligible for
I
regular
think
extension.
I think you should be able to recapture that time. There are some gray areas, but I think you should be. I am not. I don't see anything here that makes me doubt that you're going to have a problem with at least your 3.5 years. Okay.
Okay. I mean, I got confused because people told me that my H1B was filed on April 2010, though it got approved on October 2020.
Yeah.
So I was in the impression that the file date will be considered, and the date, like the April 2020, is within 1 year.
Yeah, it is. It is. I think it is a continuation of the old quota. So basically,
Mhm.
um, they filed under what is called remainder option. But what is the remainder? The remainder is 6 years minus the H1 2 years that you already used, 2.5 years that you've already used. So that math gives me 3.5, 4 years still left. I mean, in fact, you might be able to get 6 months out of July 2009 also. Because if in any calendar year, well, in any 12-month period, you have been in the US less than 6 months, you can get the whole year back. So I didn't want to get into all the math, but definitely 3.5 years should be there, no question about it.
So I mean, but I'm back in US in Jan 2011. So taking that, like it's almost 3.5 years. I'm in US now.
Yeah, then that means you should be running out of time. Have you applied for your green card?
Um, I actually, my employer is applying for my green card, and he is about to file my labor at the firm in this week.
So you came back in Jan 2011. That means you are done with almost done with 3.5 years. Your H1B was approved for how much time?
My H1B, I mean, is now, as per my latest extension, with a company C right now, and I got it extended till 2015 January.
2015 January. So we had said about 3.5 years, which means if you came back in October 20, no, hang on. When did you come back to USA? Jan 2011. So Jan 2011
Yeah, yeah.
through Jan 2014. So I'm not sure how they gave you 2015, but your math is kind of complicated. I would just be happy with whatever you've got. So, and you said you've already applied for your, or you're about to apply for green card. Um, and your H1 is now good till 2015, which month?
It's going to expire in 2015 January.
January. So the problem
January.
is, what are you going to do after Jan 2015? You may have, you can try to recapture some time, let your lawyers do the math. I would have to sit down with a pen and pencil and try to figure out how much time I can get you. I cannot tell you off the top of my head. Um, at least you're good till Jan 2015. They're giving you that. I'm not sure what their math was, but sit with your lawyer, see how much you can get out of it. Worst case scenario, you might have to be outside USA for a few months or in another status in the US for a few months if there is a gap in your H1s. Okay? I gotta take my last call. Good luck to you, sir.
Thank you so much.
You're welcome. Well, I guess there's still one more call, so let's take that. New Hampshire, go ahead, please. New Hampshire.
Yeah, hi there, Rajiv. My question number is 14.
1 second. 14. NOIR, do I need to appeal, do MTR, valid EAD? Yeah, okay, go ahead, please. I remember your case.
Yeah. So the second point, do I need to appeal or do I need to do MTR? So what is the exact difference between both of these, like appeal or MTR? Because one of your video somewhere I heard that appeal is better than MTR something.
Yes,
Difference is
yes,
there,
yes.
but I didn't get the.
Yes.
Yeah.
When you have a choice of filing an appeal or filing an MTR, filing an appeal is almost always better. Okay? I'll explain to you what the difference is. This is important for everybody to understand. So let's go over the difference. An MTR is a request from the officer or to the officer who decided your case to look at your case again. MTR can be considered to be both motion to reopen, reconsider. There's a slight legal difference between what is reopen and what is reconsider. One deals with new facts, other deals with bad application of law. They did not apply the law properly. So forgetting about that, MTR, motion to reopen / reconsider, it's basically a request to the same officer. So it stays at the same level. An appeal is a request to a higher officer that, look, your lower officer is screwing up. Can you take a look at this case? So appeal goes to the higher officer, which in many of these cases is called Administrative Appeals Office. In some other cases, it's called Board of Immigration Appeals. But for employment-based cases, you can think of it as AAO being the higher office. But here is the interesting part. When you file an appeal, the appeal still goes to the same officer who decided your case. Usually, they are given about 60 days to decide if they want to reverse themselves. So they look at your appeal and they say, this guy is making sense. I made a mistake. I'm going to reverse myself. So in other words, an MTR is automatically included in an appeal. And the reason we like an appeal is because this officer now knows that his work is going to be reviewed by the higher officer. So of course he's going to be, in my view, more careful looking at his own work. Generally speaking, an appeal is better, but not always. We have to look at the case. These days, AAO has been sending requests for evidence which are very comprehensive, ridiculously comprehensive, and sometimes it is better not to appeal cases. So it depends. Another advantage of appeal is this. When an appeal is pending, people can keep getting H1 extensions, but MTR gives you no right to get H1 extensions. Clear?
Yes. Yeah, that's clear. So how about the duration? How much duration we will get for appeal or MTR? MTR is like any duration, like we can stay like legally once we have filed MTR 1 year or 6 months or 8 months?
You cannot stay legally in either one of those cases. MTR or appeal, neither one of them gives you any right to stay in the United States. Okay?
Okay.
So
So,
don't be confused by
but you said like if we file MTR, we'll get 180 days.
No, I never
even
said
if
that.
it's
I
485 dinars.
never said that. What I said was, when the 485 is denied, you are immediately out of status as well as unlawfully present. You can be deported if they want. However, up until 180 days, no permanent damage is done to your record. If, however, you are here for 180 days, you then have a 3-year bar. So, in other words, the fact that you have 180 days without getting permanent damage does not make the 180 days legal. They are still illegal, but they don't cause any permanent problems until they hit the 180-day threshold. Does that make sense or no?
Yeah, understood. So this is different what I thought. I thought like legally you can stay 180 days. If you have valid EAD, you can work. If you don't have valid EAD also, you can stay 180 days. On top of that, it's not valid to stay. But now I understood it like it's different. Like once you get 485 denied, you need to go out of the country. That's an action process. But if you can want to stay, you can stay till maximum 180 days.
Don't make those general rules. Know what the law is, but let your lawyers help you decide what is best for you.
Okay. Yeah.
So, because there are other complications also. There is a complication. What if you have an MTR pending and you leave USA? Is the MTR considered to be withdrawn because you've left USA? So there's all sorts of problems here. Don't just make that decision. Let your lawyers help you. Okay?
Okay. Sure. Yeah. Thanks, Raju. Thanks for the time and thanks for the answers.
You're welcome. Good luck. I guess Ahsan still has a question left over. Ahsan, go ahead, please.
Yeah, Rajiv, thank you so much again.
Sure.
Rajiv, last question you answered, once 485 for some reason denied, then the person can able to change the status to F1 or can go for the study purpose, something like that, without leaving country?
No, because 485 is not considered to be status. You can only change status if you are already in status. 485 is legal, but it is not status. 485 is called authorized period of stay. If you want to be in status, keep your H1 alive. Then you are in status.
So for some reason, if I don't want to go on H1, then is there any possibility I can shift to on F1?
You cannot, not from within the United States. And once you have exhibited immigrant intent, whether or not you are going to get an F1 visa also is subject to further question. Okay?
So it's difficult to get the F1 also after once 485 denied us?
That's a very long discussion. Actually, a couple of years ago, we did 2 sessions, 2.5-hour sessions only on this issue. And there were a lot of students in that situation. But generally speaking, if you have exhibited immigrant intention by filing for a green card, getting tourist visa, F1 visa, J1 visa becomes difficult. No effect on H1, H4, L1, L2. All right?
Okay. Or I can able to right now, if my 485 is in process and still I can able to continue the study simultaneously?
I'm confused. I don't understand your question.
Like right now, let's suppose 485 is in process, and if I want to go into the study purpose or something like that, so I can able to take the admission in college and simultaneously.
So your question is, can I go to school while I have a 485? And the answer is yes, you should be able to. Okay.
Okay.
Good luck to you, Ahsan.
So
I really have to. I'm sorry.
Yes,
we've spent a lot of time on these issues. Let me just make sure nobody else has a question. If they don't, I'll
Sure.
come back to you, and I'll spend a couple of minutes more with you. So very sharply focus your questions. Guys, anybody has any questions, press *5 before I log off. Anybody has any questions, press *5. Okay. One question from Raleigh, North Carolina. North Carolina, go ahead, please.
Hi, Rajesh. I had a question last conference call regarding an employer on my H-1B. So now the employer is filing another H-1B to another company.
Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and you know, it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.